Yeah.
Tong, thank you so much for making time to speak with us this morning. I'm really looking forward to our discussion. You have such an interesting background growing up in China and receiving legal education in both China and the United States. I also note that you're bilingual in both English and Mandarin and have conducted proceedings in both languages. Can you talk a little bit about how having knowledge of more than one culture, as well as both common law and civil law traditions, influences your practice?
Yes, sure. Good morning, Ellen. I appreciate you spending time to sit down with me today. Um, of course, in today's highly intertwined global economy, being able to speak and understand clients' language, their business partners' language, and specifically as an arbitrator, being able to understand witness testimonies in their mother tongue, understand parties and their counsel's language, both in a linguistic sense and in a cultural and legal sense, certainly is a plus, viewed favorably by clients and parties involved in international business and international disputes. Um, a little bit of a personal history. I, Before I migrated to the States 27 years ago, I was a full-time faculty at a Chinese law school in Beijing, which specialized in international commercial law. There, I taught comparative jurisprudence and also practiced law part-time before Chinese courts and the CTEC. After graduation from Northwestern Law School, naturally, it was my international legal background that landed me a job at a boutique tech law firm in Manhattan. I remember clearly that was the year of the millennium, 2000. In fact, I ended up working there for the next 19 years. Its principal, Mr. Rosenstiel, is also an arbitrator and mediator, and he became a mentor and a lifelong friend to me. In the Big Apple, the melting pot, I worked with tech entrepreneurs and clients from all major continents on domestic and cross-border corporate and commercial transactions, as well as selected litigation and arbitration matters. I think it is this solid practice over a span of 24 years in New York, one day at a time, coupled with that kind of international dimension that may explain why, as an arbitrator, about half of my caseload involved international parties from both civil law and common law countries. And the other half are US domestic matters.
Yeah, that makes perfect sense that clients would want to capitalize on your very interesting and international background. So you have your own practice where you both serve as counsel and as a neutral. Can you talk about what drew you toward neutral work and the field of dispute resolution?
Sure, happy to. And my connection with arbitration and neutral work actually started when I was teaching and practicing law in China. At that time, many of my senior faculty colleagues were arbitrators, and I also represented clients in arbitration involving Sino-foreign joint ventures, and that was before 1997. So I was familiar with the typical advantages built to arbitration, especially in the international arbitration arena early on in my legal career. Um, When I started to practice in Manhattan at a boutique tech firm, I was fortunate to stay connected with arbitration, precisely because it is the preferred dispute resolution method for tech companies, where time, efficiency, and finality are prized over protracted litigation in that fast-paced business environment. As such, it was only logical for me to apply to join the roster of the AAA ICDR after I was able, which I did in 2012.
So you've worked as an advocate, litigating on behalf of plaintiffs and defendants in the commercial and the tech industry, as you've explained. Can you talk a little bit about those experiences and how the skills and knowledge you gained working as counsel in those areas help equip you for the arbitrations that you now do?
Absolutely. Uh, Walk the walk is different from talk the walk. I'm primarily a corporate transactional attorney with experience as a counsel in selected litigation and arbitration cases. It certainly gives me a 360-degree perspective by being able to look at the entire life cycle of a dispute, from contract drafting to contract performance to dispute resolution, then to post resolution enforcement. Each stage has its unique characteristics and considerations. I know how litigation operates, and I know how arbitration operates. And I think such real world experience, no doubt, will inform and enrich my understanding of disputes and my deliberation on the merits as an arbitrator. That's part of why parties select me, I believe. For example, being a long-time corporate counsel for tech companies in New York in various industries, be it software, IT, medical equipment, healthcare, economics, e-commerce, or electronics. It cultivated my multidisciplinary understanding of the legal ecosystem in which technology business operates. And to give you another example, as an advocate, I and my colleagues once successfully defended against quality claims under the UCC concerning surface condition of steel coils. In that case, I handpicked an expert witness on material science. I think experiences like this do give me a sense of ease in handling complex disputes or technology IP-centric disputes as an arbitrator, such as dealing with highly technical issues and highly technical expert testimonies.
So we've talked a little bit about how your background really well equips you for the arbitral role. What do you like best about being an arbitrator?
Sure. um, I'm an attorney with a academic background. To me, being an arbitrator is as close as one can get to combine jurisprudence with the practice of law. Um, I also like the nature of problem solving, which, of course, we attorneys do every day. It is fascinating to me how settlement, mediation, arbitration, and litigation work together, each function from different angles to advance the dispute resolution process. Uh, think about it. The process is truly a collective work product with each of the constituents doing their own part It's dynamic, it's democratic, and it's creative. In a sense that nobody knows what the outcome will exactly look like walking into an arbitration until everyone has done her part. Hey, it also feels liberating to be decoupled with a stake in winning or losing a case. Um, of course, most important, let's not forget, to me, it's a privilege and trust for parties to bring their disputes before an arbitrator. I take that solemn responsibility very seriously and I hold that trust and privilege dear to my heart.
Well, I'm sure that clients who select you are happy to hear that. I'm wondering, are there any particular parts of taking on the job of an arbitrator that you find particularly challenging, and what do you do to meet those challenges?
Good question. um, I'd say as a common law based arbitrator, with experience as transactional attorney and dispute counsel. A challenging part for me is to walk the fine line between understanding parties' presentation of the case and raising issues and questions which may be perceived as borderline advocating for one party or inadvertently strengthening another party's position. Um, like many of my arbitrator colleagues, I often ask myself, should I ask this question when parties have not raised it? Um, I think it is an art for an arbitrator in what questions to ask and how to ask. I remember in my first case, which was a large and complex international case, I sat with two big shot arbitrators. Especially the chair was well known in the field. He encouraged me to ask whatever questions in my mind to reach a decision on the merits. That indeed helped me profoundly in discharging my duty as an arbitrator. Still, I'm cautious. Some questions are more obvious than others that they should be counsel's job. When it comes to international arbitration, it can be a bit complicated when parties or their counsel come from different legal traditions and have different understandings, different expectations as to what is the fair and efficient proceeding. From my perspective, the arbitrators should be guided by the tradition of the governing law, the arbitration rules, and other supplemental rules selected or agreed upon by the parties, such as IBA rules. Meanwhile, I want to emphasize, I encourage parties to confer and agree on the conduct of procedural matters in a manner that they both can accept.
Speaking of sort of client participation in structuring and participating in the formation of the process, what are the common mistakes you see counsel make in arbitration? If you could sit down with counsel who are beginning to prepare for an arbitration, what would you tell them?
Let me think about that one. I think most of the times counsel approach cases strategically. Usually it's hard to tell it's a mistake or it's by design. However, I'd say this, it's a mistake to take your client's story without sufficient independent review and evaluation, especially when the subject matter involves technology or specialized knowledge, which may be possessed only by industry people and experts. This can happen in both arbitration and litigation. Understand it will front load cost for counsel to spend time to educate themselves on the tech issues, but failing to do so can prove fatal to their client's case and result in missed opportunity to timely settle a case and save money for their clients. To counsel who are beginning to prepare for an arbitration, my advice is take full advantage of the flexibility and arbitrator's experience afforded by the arbitration. Help your arbitrator to tailor the proceeding, the process, to your case, to the maximum degree necessary or desired. Communicate your needs to your arbitrator. For example, if you have concerns with obligations under the GDPR, if your client is a data controller or a data processor, raise your concern with a tribunal. If you come from a different legal system, ask questions about procedures and processes that you are not clear about. Do not hesitate to make suggestions to your adversary and the tribunal on procedural matters. Keep in mind, let's face it, procedurally, arbitrators are granted much wider latitude and discretionary power to address issues raised by the parties than to make initiatives not put before them by the parties. Also, if a case involves a highly specialized technological field, be proactive to propose the best processes and assist the tribunal to make the proceeding as productive and efficient as possible, since most often the tribunal is composed of generalists. They welcome targeted proposals from parties who have expertise on the technological subject matters underlying the case.
Makes so much sense. Arbitrators often have different philosophies when it comes to controlling the process, right? How much control should be perhaps delegated to the parties? How much does the arbitrator retain? And I can sense already you have a very collaborative approach to answering that question. Different arbitrators have different views on discovery, minimal or scorched earth, the role of dispositive motions. And I'm wondering if you can talk a little bit more about your views on these kind of specific procedural matters.
Certainly. Arbitration is a product of parties' contract. I respect parties' agreement as to procedural matters. Normally, I set up parameters of the framework at the first procedural conference and keep the communication channel open with parties throughout the proceeding, so I can act promptly at one or both parties' request, or as necessary to prevent the parties from falling off track, to prevent proceeding, I mean. When it comes to discovery or evidence exchange, as we refer to it in arbitration, I think the guiding principle is materiality and proportionality. If parties cannot agree on the scope and extent of the discovery, they should timely bring it to the tribunal. Regarding dispositive motion, the rules certainly allow it and have clearly defined parameters for dispositive motions. whether it is available in a case requires a case-by-case analysis. As an arbitrator, I have denied a request for a dispute positive motion and have also allowed a request for a dispositive motion. I encourage parties to raise a question to the arbitrator if it's in your mind.
Great. So we've talked really almost exclusively about arbitration, but that's not the only role you play as a neutral, right? You've done some mediation. So I'm wondering if you could talk a little bit about your experience as a mediator.
Yes, thank you. Thank you for asking. Yes, I have become active as a mediator in recent years. Mediation is about bridging the gap. That's why I like being a mediator. It requires empathy, understanding, reasoning, persuasion, and creativity. In that you let events lead you. Nothing is predetermined or taken for granted. Besides mediation of domestic disputes, I have also conducted multi-party and bilingual mediation of international commercial disputes. Commercial mediation, in my view, involves this triangular relationship among the mediator parties and their counsel. I think how well this relationship is managed is often a catalyst of how productive the mediation will be. I know you have taught and written extensively about mediation. I hope we can have a separate session just to talk about mediation when you have time.
I would love that. Mediation is very dear to my heart. Okay, last question, back to arbitration. What would you say is your distinguishing feature as an arbitrator?
Okay. I'd say I have walked the walk at every stage in the life cycle of a commercial dispute, from contract drafting to contract performance to dispute resolution and to post-resolution enforcement. And of course, I'm bilingual, multicultural, legally trained, and have practiced law in both common law and civil law countries. Last, if I may add, having disputes is a normal part of a civil society. Businesses and indeed society as a whole will benefit from resolving disputes and moving on to new opportunities. As an arbitrator and a mediator, I'm committed to working with parties in achieving resolution and finality to their disputes.
Thank you. And I want to thank you for you know, giving such thoughtful consideration to our questions and for making yourself available to me and to our CPR community at large. Thank you so much.
Thank you, Ellen. Thanks again for having me.